My never say ma PENDREAM TV. PENDREAM TV there, osia dem yopo.
The subjects I taught from the early 70s at the then Faculty of Law, University of Ghana, Legon, were Ghana Legal System, an introductory course for first-year students, and Jurisprudence, a course for third-year students, which became my signature course, as it were. Jurisprudence delved into legal theory. What is law? And it ranged over various answers to that question that theorists had put forward over the years. A book by Professor H.L.A. Hart, The Concept of Law, had been a basic textbook from my student days. There was a question posed in the analysis of Professor Hart, which has stayed with me. How do we distinguish a legal system from a gang of robbers? Is law any more than a gunman situation writ large? What is it that makes laws obligatory? We lawyers certainly do not see ourselves as robbers or gunmen. We are learned friends with esquire added to our names. Judges are lordships and ladyships. And I'm really deeply moved to see many of your lordships and your ladyships here. Again, I honestly did not expect you, but thank you for being here for this occasion. I would like us in all seriousness to consider whether we contribute to the well-being of society in a way that should make clear to the world the difference between a legal order and robbers and gunmen. When I entered the Faculty of Law, Legon, in October 1966, I began an immersion into what constitutes the corpus of the law of Ghana. Those 3 years of intensive study were not just about sitting in classrooms or in the law library. They also involved personal interactions with the lecturers and also with colleague students. Let me take this opportunity to acknowledge the impact on me from those years of Professor G.K.A. Ofuswama. He taught me contract law in my first year, but his influence on my life and understanding of law went beyond the law of contract, as he opened up his wealth of legal knowledge, his home, including library, and his very humanity to me. He literally held me by the hand after I finished Legon and took me to Oxford University to begin my postgraduate studies in October '69. Thank you, K. Dr. Thomas Mensah, who taught me Ghana legal system in my first year and became acting dean of the faculty before he left to work with the International Maritime Organization in London, was also one of my teachers whose impact has been lifelong. Apart from the time in Legon, after he moved to London, I enjoyed my trips from Oxford to his home in Golders Green, where I basked in the family atmosphere that his wife, Akosua particularly, always ensured. Even as I sat at the feet of Dr. Mensah, I honored their memory on this occasion. I cannot fail to mention the role of Professor Alex Kwapong, Vice Chancellor of the University of Ghana, Legon, in my legal education. In my third year at Legon, the dean of the faculty was Professor A.W.B. Simpson, who had come from Oxford University as part of a cooperation program that Professor Kwapong had established with the Faculty of Law in Oxford University. It was under that program that we had a memorable visit from the legendary Professor Cross, a blind professor whose authoritative work on the law of evidence, among others, remains to this day a standard reference. Under the program, students were to go from the law faculty, Legon, to do postgraduate studies in Oxford. I was the first beneficiary under that arrangement. And I went to Wadham College, where Peter Carter, with whom Professor Kwapong had signed the MOU, was my tutor, as was the distinguished international lawyer Ian Brownlee, who later also came to the Legon Law Faculty for a year. What better career and life shaping precisely orchestrated could a 19-year-old Strong Bay boy ask for than that? Professor Kwapong continued to keep a close watch on how I was doing, both as a student at Wadham and when I became a junior research fellow at Corpus Christi, till I returned to the Legon Law Faculty, initially for a term in October 73 and finally in October 74. Thereafter, till his passing, I had to make sure that he was satisfied that I was living up to all the investments he got the University of Ghana to make in my education. There were other teachers of mine at the law faculty, to all of whom I'm indebted. S.O. Jando taught constitutional law in first year, while in second year, J.K. Ajiman taught the law of torts and Kofi Deanan commercial law. Dr. Obed Asamoah taught me international law in my third year. Even as I acknowledge the influence of my lecturers, there was one colleague student with whom I worked together, not just as a fellow law student, but also as a brother in the University Christian Fellowship, E.V.O. Dankwa. He it was who stood by me as a lawyer when I was on trial from early 2001 until I was finally acquitted in 2016. He was ably supported as junior counsel during most of the High Court trial by a former student, Roland Agbanuto, of blessed memory, who had a distinguished career as a lawyer in the military and in private practice. In an interview for a UAC scholarship on 22nd December 1959, I was asked what I wanted to be in future. I boldly announced, without hesitation, that I was going to be a lawyer and subsequently a judge. Of course, with parents who ignited in us their children from a young age the zeal for reading books in the quest for knowledge, and who spared no effort and resource towards our education, ambitions like that should not surprise. My siblings and I were blessed with such parents. Our mother, who had been a pupil teacher, was also a home teacher. In my specific case, my mother also bore the brunt of my being asthmatic from about age 4. She was often with me in hospital. Forever etched in my memory is my mother lying on the floor at night beside my hospital bed during some of those episodes. I can't, however, leave out the story of 17th July 1959, when I was scheduled to take the common entrance examination. A dawn attack of asthma threatened to disrupt the plan. My mother was in Kolebu Hospital about to deliver a newborn baby. It was my father who took me to his friend Dr. H.S. Bannerman's clinic at Mamprobi. After I obtained relief from treatment there, I insisted that I was well enough to go for the common entrance examination. Incidentally, the baby girl born on the 17th July 1949 also became a lawyer, my sister though. By God's grace, asthma did not derail my educational progress. Not even when during the second term of my first year in Fansivim, Headmaster Bartels invited my father to the school for a discussion about my health and proposed that I go home for the rest of the term and start Form 1 again from the next academic year, which was that year's 1960 to start from October. Thank God I defied the adults. Parental steering towards law as a career was sealed by the close relationship between my parents and my uncle, Justice Apalu, my mother's big brother, whom I have to hold responsible for the answer I gave at the UAC interview, especially the part about becoming a judge, which I'm not able to fulfill. From when he returned to Ghana in the early 1950s, after qualifying as a barrister in England and throughout his career, ending up as a Chief Justice in Kenya after having been Chief Justice in Ghana, he was very much the role model, not only for me, but for all my other siblings. He was a model of legal erudition and wisdom, as well as judicial comportment, and had our attention from our childhood. His wife, Auntie Georgie, was very much a part of our attachment to our uncle, and she has remained a constant source of encouragement to this day. When I returned from Oxford to Legon to teach, I was soon thrust into part-time practice of law because of the state the country was in, and in my quest to contribute to a better Ghana. As junior counsel to Joe Rindolph, the preeminent legal practitioner of his generation, I was involved in cases such as a habeas corpus application for the release of some 259 prisoners in various prisons around the country, Republic versus Director of Prisons, ex parte Ango Dagomba was the name of that case, and an application seeking the release of Mr. William Oforiatta Pawili from custody, both cases during the Champong regime. Incidentally, I had become close to Pawili from the Legon student days, when he came from time to time to speak to us at the University Christian Fellowship. A few times after his talk, Pawili himself would stroll with me from the meeting place above the bookshop to my room in Legon Hall. My roommate then was his nephew, Duke Dankwa. I remember Pawili once encouraging us to go and watch the film 10 Commandments, which was then showing at the Orion Cinema, and giving us money for the purpose. And we did go to watch the film, we didn't just spend it. I was also junior counsel to Joe Rindolph, together with Professor Akila Akpasoya and Dr. Kwesi Boche, in representing Captain Kojo Tsikata before a military tribunal at Burma Hall in 1975. Joe Rindolph was undoubtedly the lawyer from whom I learned the most in legal practice. His advocacy was formidable and eloquent, a joy to behold. Ironically, we were on opposite sides in the well-known case of Amoakutufo and Attorney General, which was about whether Chief Justice Apalu had to undergo vetting before Parliament to maintain his position upon the coming into force of the 1979 Constitution. Joe was then serving as Attorney General. The trial of Flight Lieutenant Rawlings after the May 15, 1979 uprising obviously thrust me into the national spotlight, irreversibly, I may say. It was a time of great agitation in the nation. A line of Rawlings' statement to his investigators, "Leave my men alone," which was quoted in the opening prosecution statement by the Director of Public Prosecutions, G.E.K. Akins, captured the imagination of the nation, appearing on the front page of the Daily Graphic. It showed a readiness to take responsibility as a leader that endeared him to many. I was led in that defense by the then president of the Ghana Bar Association, Mr. Bosman, as Betty mentioned. A number of other reputable lawyers, such as Emil Short, were also involved as counsel for the co-accused. And as we know, that trial ended with Rawlings being sprung out on the morning of 4th June 1979. A few days before 4th June, on Saturday, 1st June, I was going to the Air Force Mess in Burma Camp for the wedding reception of my classmate, Kwamna Anaman. Driving from Legon, I had a problem with my car just about when I reached the roundabout at 37 Hospital. I decided to park the car at a convenient location and get a taxi to the Air Force Mess. On arrival, I took out a note to pay the taxi driver, who then was having difficulty finding change. Across walks a young man, obviously a soldier, but not in uniform, who must have recognized me from my being at Burma Hall that week for the Rawlings trial. He asks the driver how much the fare is, pays the driver, then as the taxi leaves, he turns to me and confidently says, "Don't worry, your man will be out soon." The calm assurance of that young soldier in essentially telling me about an upcoming coup d'etat is quite unforgettable. Ghana has come a long way since those heady days. The Fourth Republic has provided the longest period of stable constitutional democratic order for the country. This is something and guard jealously, not take for granted. The legal profession, and in particular the judiciary, have important roles to play in sustaining this order. So we must examine ourselves honestly and speak frankly if we are to deserve the confidence of the society. I found it sad during the election petition following the December 2020 presidential election that the expression unanimous FC became the name of our Supreme Court. The challenge to the declaration of results formally announced on 8 June 2020 by the chairperson of the Electoral Commission required a fair and just adjudication. It was not in dispute that the figures of the outcome of the election that were announced by the chairperson of the Electoral Commission were corrected in a press release by the public relations officer of the Electoral Commission. Subsequently, the figures that were presented in response to the petition by the Electoral Commission were also different from what the chairperson had announced. The constitutionally designated returning officer, the chairperson of the Electoral Commission, even though she had deposed to an affidavit verifying the answer of the Electoral Commission and was supposed to testify, did not testify to present the authoritative final figures, much less explain the ever-changing figures from the Commission. To this day, therefore, the country has no definitive accounting for the 2020 presidential election. In the face of evidence of her failure even to be in attendance at the process in the collation center at the EC head office, the declaration of results that she made was even more problematic. Unanimous FC was the verdict of the people on the proceedings in the Supreme Court, which shielded the returning officer from accounting to the people of Ghana. The negative reaction of ordinary people to the appearance of judges to participate in the swearing-in of the new president on 7 January 2025 was an unfortunate reflection of the people's attitude to the unanimous FC. I may also say that from the point of view of President Mahama, whose election petition was dismissed by the unanimous FC, vindication came comprehensively in December 2024. What he could not have done with a hung parliament after the 2020 election, he now has a chance to do decisively with a supermajority in parliament. This vindication, however, comes with a heavy weight of responsibility and expectation, which I believe the president is conscious of. Let me recall, sadly again, that in December 2020, the people of the Santro Kofi, Akpafu, Likpe, and Lolobi South traditional areas, by an announcement on the evening of 6 December 2020, were prevented from voting in the Hohwe constituency they had previously voted in under a valid constitutional instrument. Yet a winner was declared of the election in that constituency, and he served in parliament in a period when the citizens of Ghana in the South traditional areas had no representation in parliament. That was an undermining of the very fabric of the Republic of Ghana, in addition to being a violation of the fundamental human right to vote of those disenfranchised citizens. Professor Margaret Kweku and other petitioners first sought from the High Court in Ho remedies for the human rights violation. The High Court in Ho granted an interim order of interlocutory injunction. The then Attorney General ran to the Supreme Court and had the court pronounce that since one of the remedies being sought was the invalidation of the results of a parliamentary election, the procedure of an election petition in the High Court was the only procedure to be used to bring the matter to court. The Supreme Court cited some of its earlier decisions in cases involving J.H. Mensah and Baba Jamal, among others. The interim order of interlocutory injunction lapsed. The petitioners then filed an election petition and went through a process of trial, where again, the Electoral Commission chose not to testify to explain their conduct. In July 2024, the High Court decided that it did not have jurisdiction over the matter. Following an appeal, the Court of Appeal recently quashed the decision of the High Court, but now stated a case for the determination of the Supreme Court. Judicial remedy for the disenfranchisement in December 2020 of Ghanaians in the South traditional areas is still pending. It cannot be said that the subsequent creation of a Gwan district and a Gwan constituency are sufficient to remedy the injustice to the people of Sao. For one thing, the mere denomination of a district and a constituency does not provide the development resources that are the legitimate aspiration of the people. For the period, they lacked representation in Parliament, and a share of the resources that could have been available through a member of Parliament, I dare say they are owed reparation. The historic injustice of the declaration by the EC of the election of a member of Parliament for a constituency to which they belong but were denied a vote in awaits judicial resolution. Please remember that the EC itself has admitted that it would have been illegal to have asked the voters in those areas to vote in the Boem constituency in December 2020. Yet, that is what the constitutional instrument which the EC has claimed in its defense to the election petition to be the applicable instrument. That is what that instrument would have required. There is an unsettling judicial contradiction, which I must also point out. While the Supreme Court, in respect of Sao, insisted that an election petition in the High Court was the only way to invalidate an election petition, when it came to an action initiated in the Supreme Court to invalidate the result of a parliamentary election in Asin North, the Supreme Court dismissed an objection to its jurisdiction to invalidate the parliamentary election that was based on its own previous decisions, went ahead to grant initially an interlocutory injunction preventing the elected member of Parliament, Honorable Jachi Kwesen, from being in Parliament. Remember, this was the time the e-levy was being pushed through. And eventually delivered a final decision invalidating the Asin North parliamentary election. The resulting by-election, however, saw Honorable Jachi Kwesen win again with an even bigger margin. Despite all the machinery of government being massed up against him, new roads suddenly being constructed in the area, the president, vice president, and the whole machinery of the party in government moving in to campaign against him, he maintained this remarkable victory streak in December 2024. During the period when the interlocutory injunction prevented him from being in Parliament, the people of Asin North were deprived of representation in Parliament at a time when important national issues such as the e-levy were under consideration. Honorable Jachi Kwesen, who also faced an obviously politically motivated criminal trial from 2022, was fortunately acquitted in April 2025 on all charges upon a submission of no case. And he now serves our nation not only as MP for Asin North, but also as the Deputy Minister for Foreign Affairs. I must also speak about my own experience of being tried and imprisoned, as these two provide lessons about the misuse of both executive and judicial powers. Upon an application by my lawyer, EVO, the Supreme Court, by a 5-4 majority, declared unconstitutional both the so-called fast-track High Court, before which I was arraigned, and my having been summoned to the court in the name of the president. I think I may be one of the only people, I'm sure I'm the only person since Republican Ghana who has been summoned to a court in the name of the president. And that was despite the fact that the Constitution requires the independence of the judiciary. Now, after that 5-4 decision, as Betty pointed out, President Kufuor immediately took steps to to appoint 2 new judges to the Supreme Court for the express purpose of enabling Chief Justice Redu, who was one of the minority in the 5-4 decision, to empanel those 2 new members of the Supreme Court as part of the review panel. The then Attorney General, later President Nana Akufo-Addo, held a press conference after the Supreme Court decision, condemning the judges in the majority for what he called a perverse decision. According to plan, the review ended up overturning the earlier decision by a 6-5 majority. Police were sent on the Sunday after the first decision of the Supreme Court to the church where I worship to arrest me. I had always made myself available to the police. The only reason for that particular event, immediately following the Supreme Court decision in my favor, was to show that even that court decision did not matter to the powers that be. Later that same week, new charges were brought in a normal high court against me. These were again dismissed on the basis that they were unconstitutional, being in breach of the clear constitutional provision against criminal legislation being used retroactively. Once the president got the review panel he wanted, and the Supreme Court now went his way, I was arraigned before a fast-track high court again. And on June 18, 2008, which was not a day set for judgment in the case, and whilst there was pending in the Supreme Court, as again Betty mentioned, a ruling as to whether the IFC had immunity from being subpoenaed as a witness for the defense, the trial judge, who had previously decided to await the decision of the Supreme Court, now announced that the day of judgment has come. She disregarded the fact that my lawyer had written to notify the court he had to travel out of the jurisdiction. He said to me, "You are a lawyer yourself," unquote. I pointed out that I was being represented by counsel throughout the trial, and I did not even have the brief for the case, so I could not conduct my defense myself. The person who came to court with me that morning, the judge required that we be in court as early as 8 a.m. that day. And so I had to pick him up. So that person was my lifelong friend, more like an older brother, John Henry Mate Newman, President Mills' chief of staff. So I picked up Mate from his office to go to court, and at the end, I had to give him my car keys to drive the car home. There was no question that the judge was determined to send me to prison at all costs that day, urged on by the then Attorney General, Joe Gatti, who had not appeared in court for about 1.5 years since the judge had been adjourning proceedings to await the appeal in respect of the issue of this IFC being subpoenaed. He was in court that day, however, with his full team, about 5 of them, for no other purpose than to have me convicted and sent to prison. The transcript of the proceedings that day makes interesting reading. It was published in the Legon Observer at the time. I encourage lawyers and law students and members of the public in general to obtain that transcript and read it for themselves. The value of legality and justice is something that governments, especially those who claim to be committed to the rule of law and democracy, must recognize. Otherwise, they create distrust for the very constitutional and legal order that is their claim to authority. They become no different from the gang of robbers that Professor Hart wanted to differentiate a legal system from. We lawyers in particular, judges most especially, must be in the vanguard of the respect for legality and justice. On my first Sunday in prison, I attended a church service. A pastor came from Asamankesi, by name Jones Owusu-Ejei. Exodus 50:20 was one of his 2 texts for the sermon. Joseph saying to his brothers, "You meant it for evil, but God meant it for good." On the 10th anniversary of my imprisonment, my wife and I joined Pastor Jones and other colleagues who had organized a medical mission to the Nsawam prison to provide free medical care, including surgeries to inmates of the prison as well as prison officers. A prisoner came to me. He reminded me that he was the one who had come to ask if I had medication to help another prisoner who had a bad asthmatic attack. I had given him some medication, which he told me had saved the life of the other prisoner. He then told me also that the other prisoner had eventually come out of prison and was outside the country at the time, and always recalled with gratitude how the medication from me had saved his life. The prisoner speaking to me then added his own observation that it would have been unlikely, unfortunately, that the other prisoner could have been taken out of the prison to receive urgent medical care. I had a better chance to be taken out, so it was okay that I gave away my medication. Last December, a gentleman left a message for me at my mother's house, not far from here, asking me to call him. When we spoke, he said he had been at the Nsawam prison with me and that he had asked me for legal help with his case. I had introduced him to a young lawyer who had visited me in prison. The lawyer helped him without charge. After getting out of prison, he had gone abroad to pursue studies, and on returning to Ghana in December, had tried to get in touch with the lawyer to express his appreciation, only to learn, sadly, that the lawyer had passed. The gentleman has not only earned his doctorate degree studying abroad, but is now part of a high-powered advanced intelligence research group based at a university in Japan. God Meant It for Good was the title of my reflection on the first anniversary of my imprisonment. It was published in the Daily Graphic. On the 5th anniversary, my title was 5 Years On, His Mercies Never Fail. That was 2013 during the election petition. And on the 10th anniversary, I Overflow with Praise was my title. All these reflections were published in the Daily Graphic. By God's grace, I have never harbored any grudge or felt any bitterness against any of those who were involved in all that happened to me during the Kufuor regime. However, I do not wish such a desecration of justice as I experienced on anyone, no matter their political affiliation. I do not want to hear of the police going to a church on Sunday to arrest anyone when that person has gone to the police or to court whenever required to do so. In fact, political affiliation, settling political or personal scores, or wanting to show where power lies should not be the reason for criminal prosecution. Not even for a criminal investigation. In the end, on 30th November 2016, I was acquitted on appeal. Earlier, the Supreme Court had ruled that the IFC does not have the immunity that the High Court judge and the Court of Appeal had claimed it had. A judgment that was delivered by the inimitable Justice William Atuguba. At the Court of Appeal, the immunity provisions of the statute of the International Monetary Fund had been ascribed to the IFC, and the Supreme Court overturned that. In the midst of what I went through during this whole period, my wife Esther in particular stood with me with total dedication and in such amazing ways, which is why I'm still here and alive. The Free Tsatsu campaign, which she and close friends, notably Kwesi Pratt and Trichi Opoku, launched for justice in my case, generated public awareness and mobilized incredible support across the nation and internationally. On the morning of Sunday, 16th November 2008, Esther came to the Nsawam prison to bring me food, as she did daily during my imprisonment. She found out that I had been rushed to the Nsawam hospital after suffering a bad asthmatic attack during the night. She rushed to the hospital and saw the bad condition I was in. She was the one who, with the permission of the director of the prison, arranged an ambulance that came from Koforidua to take me to the 37 military hospital. A close friend and brother, Alhaji Yusuf Ibrahim, had arranged for me to be attended to there. I was sent to the intensive care unit. Eventually that evening, the doctors at 37 decided that I needed to be moved to the National Cardiothoracic Center at Kolibu. They had spoken to the director, Dr. Frimpong Boateng, who agreed to have me in cardio. By the time I got there, in an ambulance from 37, Dr. Sribo, the deputy director, whom Yusuf had again contacted, was waiting at the intensive care unit to attend to me with the urgency my situation required. That week was a life and death struggle. The goodness of God and His grace were manifested so powerfully to me in that time, as indeed throughout my life. They were manifested in the love and care of my wife, the compassion of the director at the Nsohom prison, the professionalism and attentiveness of the medical personnel at each hospital, the love and care also of my mother, siblings, children, other family members, and friends who helped me through the ordeal that I have only given you a glimpse of. I could not have survived to be here today if I did not have all that love and support. On this wonderful occasion, allow me to invite my wife Esther to join me here.
PENDREAM TV. Now, so far so good. Say open online portal e Ghana. Nipa share, nipa follow, nipa comment here. To my best of knowledge, without any biases, PENDREAM TV.